Welcome to the Supreme Court Podcast.
All opinions expressed in this podcast do not reflect the views of the Supreme Court. For clarity, the text of the decision prevails.
Imagine you are a devoted wife. You're lying in bed with your husband and you receive a message about his supposed infidelity. You went to the supposed love nest, saw his alleged mistress, and then there's your husband and a 4-year-old boy who calls him daddy. In an instant, all your suspicions confirmed. Your husband has been cheating on you all these years. Hi, I'm Attorney Mike Navalio, Supreme Court Chief Communications Officer. It's the 20th of September 2024, and today we talk about a sensitive yet very common issue in marriages, marital infidelity. But is marital infidelity by itself already a form of psychological violence under the Anti-VAWC Against Women and Their Children Act, or Republic Act No. 9262? This was the main ruling in the case of XXX versus People, penned by Associate Justice Ramon Paul L. Hernando, a ponencia which generated 3 dissents and several concurring opinions, proof of how contentious the issue is. And joining us to discuss this is Attorney Pauline Carillo from the Office of Associate Justice Hernando. Hi, Attorney Pauline. Welcome to the Supreme Court Podcast.
Hi, Attorney Mike. Good day.
All right. So, this issue of marital infidelity, it's very controversial, very common as well. But how do we situate this in the context of RA 9262 or the Anti-VAWC Against Women and Their Children Act? Can we say that if someone commits marital infidelity, that already is a violation of VAWC law?
No, Attorney Mike. As we will discuss later on, there are still elements to be proven in order for us to determine whether marital infidelity constitutes psychological violence punishable under the Anti-VAWC law.
Let's talk about the nexus, the link between psychological violence and marital infidelity. Can you tell us a bit more about the connection?
Marital infidelity still continues to be a form of psychological violence, but this case reiterates that it is marital infidelity resulting in emotional and mental anguish that is punishable as psychological violence under the Anti-VAWC law.
All right. And this case you're talking about, let's try to concretize this by explaining to our listeners what happened in this case of XXX versus People. In the introduction, I said she discovered that her husband, as a child, has been living with the alleged mistress. So tell us more about what happened in this case.
Okay, so in this case, there was a husband and wife who had a kid. He stayed in the city during weekdays for work while he would go home to his family in the province, to their family home on weekends. However, everything changed when the wife received word from a co-worker that someone has been attempting to contact her and inform her that her husband was living with another woman in Makati and that they had a 4-year-old boy together. She was even sent pictures where she recognized their family vehicle parked at the alleged house of such mistress. The wife then located the address, hunted down the vehicle, and found that indeed their family vehicle was parked in the location of the alleged mistress. She knocked at the gate, pretended to ask for the owner of the vehicle, to which the husband's alleged mistress came out. At this point, she couldn't control herself anymore. The wife grabbed the alleged mistress's hands, pulled her outside the gate, and demanded that her husband be brought outside. The husband here eventually appeared only after being threatened that she will go to the workplace instead. Just as the police were about to pull apart the ensuing commotion because of all this, a little boy ran outside and called the husband daddy. This only confirmed to the wife that there was extramarital relation.
Attorney Pauline, at that point, how did the wife react when she heard the words daddy from the 4-year-old child?
It was a commotion. There was a shouting match that even led them to be brought to the barangay hall. When they were at the barangay hall, this is where the husband eventually admitted that indeed the child was his. As a result, the wife requested that a blotter report be recorded, detailing this incident.
So there was a case filed
Mhm.
at the regional trial court. How did it reach the Supreme Court?
The trial court here held that there was psychological violence due to marital infidelity, as evidenced by the clear distress and the readily apparent anguish in the narration of the wife of what happened in that confrontation.
How did it manifest in court? The wife testified. What did the trial court observe, and was it corroborated by the other testimonies?
The trial court here was able to observe the narration of the wife in open court, where she emotionally broke down, cried. This was even corroborated by the wife's friend and companion at the time of the confrontation, and she testified that the wife was visibly emotional, would not stop crying, and even appeared to be in immense disbelief that she had been cheated on by her husband.
And so, was the husband convicted by the regional trial court?
Yes, and this was affirmed by the CA.
So this case went to the Supreme Court, and we know that this is a very contentious issue because you have several justices with different opinions on the issue, 3 dissents, several concurring opinions. But let's talk about the ponencia first. How did the ponencia by Justice Hernando resolve the issue of psychological violence, marital infidelity as a form of violation of the Anti-VAWC Act?
The Supreme Court here affirmed the conviction of the lower courts and held that the elements of psychological abuse were satisfied. The two most important and contentious elements in this case was the emotional anguish or mental suffering that was the effect, and the psychological violence as the means employed. The court here was able to determine that the emotional anguish and the mental suffering as an effect was evidenced by the trauma narrated by the wife upon her discovery of her husband's cheating. Meanwhile, psychological violence here as the means employed is evidenced by the one-time sexual encounter outside the marriage, which resulted in a child. This was furthered by the discovery of the wife that she has been deceived by the clandestine extramarital relation, and that this was kept from her, consciously hidden from her for 4 years, and the fact that she only discovered this from a stranger. So all these taken together, the court found that the elements of psychological abuse were present.
And at this point, Attorney Pauline, how important is it that there's a visible, demonstrable mental anguish caused by the marital infidelity proven in court for the court to say that this is a violation of VAWC?
In this case, the Supreme Court gave credence to the uniform findings of the RTC and the CA about the clear testimony of the victim in open court, narrating in detail the circumstances that led to her anguish due to the cheating of her husband. The fact that this was even corroborated by a witness bolsters her case.
So to be clear, it's not just marital infidelity. There must be mental anguish, and that has to be proven.
Yes.
But this particular ruling is contested by the other justices because it seems like there is already, this particular ruling was contested by other justices because you're saying that there's a presumption that if you commit marital infidelity, you already intended to cause anguish. And the other justices, specifically Justice Caguioa, Justice Mario Lopez, are saying you should prove intent to cause mental anguish. Even Senior Associate Justice Leon was also making that point. Isn't there a need to prove that that man, the husband, when he said that it was a one-night stand, they did not intend to cause mental anguish to the wife? So, what was Justice Hernando's explanation for this? Why is it presumed that there's an intent to cause mental anguish.
The court here said that in instances where marital infidelity is the means employed, you can presume specific criminal intent the moment the husband or the perpetrator commits the act of marital infidelity, because what else can an adulterer expect to cause upon the spouse if not pain or anguish? So in this case, that causal connection that is bridged by the specific intent is presumed, but it does not dispense with the fact that you have to prove the fact of marital infidelity as well as the fact of mental anguish on the victim.
So he's saying that when you commit marital infidelity, that necessarily means you intend to cause anguish on your wife, because if you're a dutiful husband, you wouldn't even want to do that. That's the in essence, that's what the Ponensya is saying.
Yes, because what else could you have expected to cause upon the victim or your spouse? What the as Justice Singh has pointed out here, marital infidelity does not happen by accident. So obviously, when you commit the act of infidelity, there is already a deliberate choice on your part to breach that spousal trust. And so the court can presume that there is an intent to inflict harm.
But there's one case that was extensively discussed here, the case of Acharon. And it's interesting because it's Associate Justice Benjamin Caguioa, Alfredo Benjamin Caguioa, who actually was the ponente of this ruling. And so he echoed this discussion in his dissenting opinion. And he was saying, in Acharon, you needed to prove intent that he withheld support. But before we discuss that, I mean, what happened in Acharon? Can you give us a brief background about what was that case about?
In Acharon, the issue, or at least the means employed there to cause psychological violence, was the willful and deliberate refusal to provide support. The court there actually acquitted the accused because in that case, it was not proven that the accused had a willful intent. Rather, it was just an inability to provide support.
So when you can't afford to provide for your kid, that shouldn't be taken against you.
Yes,
right?
the court there distinguished between willful refusal to provide support and the mere inability to provide support. In the first case, there's a deliberate refusal on your part. In the second, you just can't by financial means.
So in Acharon, that was clear, right? You cannot fault someone who has no means to support a child, right? But how different is that from this case here, where there's marital infidelity? That's the means for committing psychological violence.
The court here recognizes the ruling in Acharon, but holds that Acharon is inapplicable in this case where the means employed is marital infidelity, because unlike financial inability to give support due to means, which led to the acquittal of the accused in Acharon, there are no similar external circumstances that prevent a husband from otherwise committing marital infidelity. Even from the host of reasons cited by the dissent, such as insecurity in earnings, loneliness due to distance, lack of communication, or the mere compulsion of lust, all these are within the husband's mind, will, and control. And therefore, when he acts on that impulse, for whatever motivation that may be, then that willfulness or that intent is already satisfied.
What about the point of some of the justices that marital infidelity per se is not one of those penalized under RA 9262?
The court here found that the offense is the causing upon complainant mental and emotional anguish. Psychological violence, as defined explicitly in Section 3C, expressly includes marital infidelity in its enumeration of the possible acts and omissions that can result in psychological violence. And here, there's no distinction in the law, or at least in the definition, as to frequency, repetition, or continuity. Which is why, if I may quote, the court held that an illicit sexual encounter committed by the married male person, however casual or infrequent, constitutes such marital infidelity that can amount to psychological violence.
Now, let's talk about the implications of this ruling. Because when you now punish a husband for committing marital infidelity and causing mental anguish as a violation of VAWC, you can't punish the woman if it's the wife committing the same. So the argument is, isn't this discriminatory?
No, Attorney Mike, it has already been decided in the case of Garcia versus Drilon that the anti-VAWC law is constitutional and it does not offend the Equal Protection Clause. It's because it is based on a valid classification and it rests on substantial distinctions. Here, the court explained that the state favors and affords protection to women over men because historically and statistically, women are still the usual and most likely victims of different forms of discrimination, violence, and unequal power dynamics.
And one interesting aspect of this case is the interplay between, of course, the criminal aspect, which means you have to prove intent and all the elements in order to protect the presumption of innocence of the accused. But at the same time, you have some justices saying we also need to look at the law from the point of view of the victims and the impact on the victims. So tell us about how the ponensya try to balance these aspects of the ruling.
By affording, Attorney Mike, by affording a presumption regarding the intent to inflict emotional anguish when marital infidelity is committed, the decision here does not dispense with the burden of proof on the part of the prosecution to establish certain facts. That is, the prosecution still has to prove the fact of marital infidelity as well as the fact of the emotional and mental anguish suffered by the victim. The presumption as to the intent only recognizes that it is easy and very convenient to simply invoke other defenses if one is required to prove that intent. As Justice Lazaro Javier has put, it's easy to invoke boredom, curiosity, a sense of adventure, and a host of other motivations to feign that specific intent to inflict harm on the part of the wife.
But just to be clear, Attorney Pauline, not all forms of marital infidelity can actually lead to mental anguish.
Yes.
Right? There are exceptions to this presumption.
Yes, that's correct. The court has actually recognized that there are several types of arrangements within a marital relationship that do not rise to the level of criminality in case marital infidelity is committed. These are non-traditional family setups, modern relationship arrangement, estranged relations, consciously consenting spouses, and even open relationships.
So in a sense, if they have this arrangement where you can find your new partner, I can find my own, we don't necessarily have to go to court to annul our marriage, then that's fine. There's
Yes.
no injury, no VAWC violation.
Yes, because these can be used as defenses to disprove the fact that there was marital infidelity or even the fact that there was emotional anguish suffered by the victim.
All right. I hope this discussion today clarifies a lot of questions about the ruling. Although it's very interesting to see how the justices reasoned out their points of view in this case. So thank you so much, Attorney Pauline, for discussing this case with us.
Thank you, Attorney Mike.
Right. And if you wish to read the full text of the court's decision, you can go to the Supreme Court website and e-library. Just search for XXX versus People, GR number 252739. Here's Steph Atendido Beltran for this week's Roundup.
At the Supreme Court this week.
The Supreme Court upheld the resolutions of the Commission on Elections, or COMELEC, canceling unwarized registration as a party list organization. The court held that under the Constitution and the Party List System Act, it is the COMELEC that has exclusive jurisdiction to rule on the cancellation of party list registrations. The court also ruled that the cancellation was proper, as it was based on Section 6, Paragraph 5 of the Party List System Act, which states that violation of election laws, rules, or regulations is a ground for the cancellation of a party list's registration. The Office of the 2025 Bar Examinations Chairperson, Associate Justice Amy C. Lazaro Javier, issued Bar Bulletin No. 1, Series of 2025 on the conduct of the 2025 bar examinations, modality, coverage, schedule, and syllabi. Continuing on the reforms from the last 4 bar exams, the 2025 bar examinations shall remain digitalized and localized following a condensed 3-day examination schedule. You may download a copy of Bar Bulletin No. 1, Series of 2025 from the Supreme Court website. In another ruling, the Supreme Court said that the Commission on Audit, or COA, cannot expand its audit powers to include imposing administrative penalties. The court reminded COA that its conduct of an audit is not an exercise of the government's administrative supervision over public officers. As the COA's authority is limited to initiating the proper administrative, civil, and/or criminal action upon discovering a violation during an audit, the imposition of administrative penalties is outside the scope of its audit powers. Meanwhile, the court led the second leg of discussions on the proposed amendments to the Rules of Criminal Procedure in General Santos City on September 17, 2024. Among the proposed amendments to the Rules of Criminal Procedure are changing the term offenses to crimes to include crimes under special penal laws, using a certified DNA test result as a new ground for a motion for new trial, and giving to the Department of Justice exclusive jurisdiction to conduct preliminary investigation. The Supreme Court also sought input, suggestions, and feedback from judges and court employees from first and second level courts in South Cotabato, Sultan Kudarat, and Sarangani on the proposed new guidelines governing the conduct of judges and court personnel at the fifth leg of the Ethics Consultative Caravan held in General Santos City on September 18, 2024. Finally, the Supreme Court has ruled that in cases of rape committed by force, threat, or intimidation, it is not required to prove that the victim resisted. It is enough that such force, threat, or intimidation existed and was strong enough to prevent the victims from asserting their will, determined from the victim's perspective. The court clarified that previous decisions stating that a woman cannot claim to be a rape victim unless she resisted are contrary to current doctrine. The court stressed that the belief that if a woman does not resist, then she consents to the rape is unacceptable in any civilized society. This wrongly presumes that men are entitled to free access to a woman's body at any given time and place. The court said it is time to strike down such uninformed and ignorant views.
And that's your Supreme Court this week. I am Tiffany Doblatran, Supreme Court Information Officer.
And that's our podcast this week. Join us again next time for a detailed discussion of select cases decided by the Supreme Court. I'm Attorney Mike Navalio, your Supreme Court Chief Communications Officer. You can catch this podcast on the Supreme Court Public Information Office's accounts on X, Facebook, Instagram, Threads, and YouTube. You can also catch previous editions on our website. This podcast episode was produced by the Supreme Court Public Information Office with Attorney Jen Tuazon Erania as researcher, Victor Laranio and Jerome Bato Malake as sound editors, and Tyke Flores as web editor.